We beat the DUI case by winning the motion to suppress in court. That motion to suppress hearing was an hour-long hearing where both officers testified, and after all the testimony, I argued to the judge that the police officers violated my client's Fourth Amendment rights and that they illegally detained him originally or stopped him in the first place, and then that they continued the detention beyond the necessary needs of the investigation. The judge gave me a split ruling. That's up next. This is a final episode of a three-part series watching a DUI case from beginning to end. If you haven't seen episodes 1 and 2, you can check those out by clicking the link above. It doesn't really matter which order you watch it in, so you can finish watching this one and watch those ones in a few minutes. But if you're that type of person, you got to watch them in order, yeah, go ahead, click up there. My guy's found in the driver's seat of a sports utility vehicle parked on the side of the road. The cops walked up to the car, knocked on the window, got him to step out of the car, and they conducted a DUI investigation. It didn't go well from there. He ends up being arrested and calls me to take over the case.
Turn the car off. Open the door. Let me see your hands. Put the keys on the dash.
After all the testimony came out, my first argument to the judge was that the stop, the initial detention, was unlawful. After all, my guy's just stopped on the side of the road. Technically, he's done nothing illegal. He's just stopped in his car. So if I win that motion or that part of the motion, then everything goes away, because the police officer's first action would have been an illegal one and everything thereafter would have been suppressed. But the judge didn't buy that argument. The judge said that even if his actions of parking or stopping where he stopped were 100% legal, the location of the stop is suspect enough that the police officers have a duty or obligation, or at least a reasonable suspicion, to knock on the window and do a welfare check. So regardless of whether the situation is a legal one or not, whether their actions of my guy are legal, the officers still have grounds to knock on the window. I next argued that there was no reasonable suspicion to do a DUI investigation on my guy. The judge agreed with me. I'm not going to get into all the details as to why and the legal arguments that were made, but here's what you need to know. Before you can make your arguments in court, and before you can make your arguments on how to get out of a DUI arrest in the first place, you have to have a baseline understanding of what type of officer you're dealing with. I made a whole video on this and how to get your bro out of an arrest, and the critical aspect is identifying who you're dealing with. I'm going to play a clip from the video right here. What type of officers do you think we're dealing with?
He ain't driving anywhere, there's no doubt about that.
You want
He was just parked here like this?
just like this, yeah.
Alright, yeah. I mean, I'll do it. Yeah, I'll do it.
Leave your comments down below. Do you think these are aggressive cops? Do you think these aren't the ones likely to make an arrest? I'll let you make that decision. So the judge granted my motion to suppress with regards to the roadside sobriety exercises. But here's the problem. Remember when I first talked about the DUI stop, and if that was suppressed, that everything else thereafter would be suppressed and the case would have to go away? Well, that's not the case with the roadside sobriety exercises. Just because the judge granted my motion to suppress doesn't mean the case has to go away. It's just the particular evidence that was suppressed is no longer admissible in trial. Recall, the judge said the stop, the initial detention, was lawful. So technically, the state can proceed to trial and introduce evidence of everything the police officers originally saw walking up to the vehicle. It's just everything else would be excluded. If they want to roll their dice with that in trial, that's their prerogative. And I had to explain that to my client because he was just happy that we won the motion to suppress, not realizing that we were still going to be prepping for trial the very next day. So, not knowing what the state was going to do, we started working. We never got an offer from them that first day. Do you take a sweetheart deal if they give it to you at that point? Do you fight it in trial? That's a decision that has to be made with the client, obviously with legal counsel. In this particular case, as we started prep for trial, I got an email from the prosecutor and all the charges were dropped. Hit that like button. See you in the next one.